Well, hello there to all the good people of Ohio and beyond. This is Aaron Knapp, and you're tuned into Unplugged, broadcasting without permission. This is a place where the truth gets louder and we dig deeper, and where we always remember be lawful, not awful. If you want the full stories, the documents, the videos, and everything they don't want you to see, head on over to Aaron Knapp, unplugged.com, my new home for every investigation, every episode, and every update. And while you're here, be sure to like the video, follow the page, and hit subscribe, and share this with someone who needs the truth. We're building something real here. We're building something fearless, and we're doing it together. Welcome to Unplugged. Let's kick this thing off.
Plug with Knapp. Yeah, we cut through the noise. No script, no leash, no polished decoys. Broadcasting without permission. We don't ask. We lift the curtain and we drop the mat.
All right. I'm going to forego with the theatrics this morning here because I want to get this podcast, get the information out there before I've taken the youngster to school this morning. But would like to welcome everybody here. Good morning there to Lorain and beyond. Anybody out there listening this morning, this early morning, 5:35, 5:30. Anyway, I want to do this little podcast here today that kind of goes over the story that I wrote last night. It's a companion piece to go along with the new filing that CCI filed recently against the county commissioners, which, again, as I was trying to explain to one person this morning, is why we were discussing engineering stuff on the page, but it really boils down to that these things are all intertwined when it comes to our county and our city. And so we're going to talk today a little bit about the filing that they didn't want you to read that was filed on January 2nd. So on January 2nd, CCI filed a 28-page opposition brief that appeared quietly on the federal court docket in the case of Cleveland Communications, Inc. v. Lorain County Board of Commissioners. It arrived without ceremony, without announcement, no press releases, no junkets, nobody, jumping out there to talk about it. Nobody even said anything. It's been 4 days, 5 days. What is that? I think today's the 6th. Correct, the 6th. So no statement explaining that the legal theory Lorain County has relied on for more than 2 whole years has just been directly confronted in detail on the record. The silence is not incidental. It's part of their story. For more than 2 years, they've been telling this story to us about a carefully curated version of this dispute, a version that in which the controversy begins and ends with one single vote, and a version in which the county's actions are framed as just routine, technical, and ultimately harmless. A version in which the recession, or I guess the rescission of the contract is treated not as the culmination of a broader course of conduct or misconduct, but as only legally relevant fact that ever mattered, right? The January 2nd filing challenges the version that the commissioners are putting out head on. It is not a filing that quibbles over procedural margins or attempts to regulate settled points, right? It doesn't argue around the edges. It attacks the county's preferred narrative at its core. For more than 2 years, the county commissioners have insisted that this case is nothing more than a failed contract rescinded by a single legislative act, right? With no legally cognizable injury beyond that moment to any party. Now, according to the county's filings, everything else is just noise. Context is irrelevant. Conduct that occurred before or after the vote is immaterial to them. Legislative immunity, once evoked in their mind, ends the inquiry before it begins. It's done. CCI's opposition brief says that story is incomplete, misleading, and legally pretty much insufficient. And that's been the story all along with all of this. But the filing alleges that harm that extends well beyond a rescinded vote. It describes damage to CCI's business reputation and goodwill It alleges denial of existing and future business opportunities. It details interference with operational systems that continued independently of the rescinded agreement. And most significantly, alleges that retaliatory conduct that occurred after, this is important, after CCI exercised its right to seek judicial relief. And, you got to understand that that's huge because that makes it something different. Those allegations matter not because they've been proven, but because of where the case currently stands on a precipice, right? It's at this stage of litigation where the court's not deciding who's telling the truth. It's not weighing evidence or assessing credibility. It's deciding like whether these allegations taken as true as federal law requires, plausibly state claims.
Uncle Bobby is annoyed finding my school computer for school.
Okay, you can chill. We'll get it. It's not even time to leave yet. It's 5:39. We don't leave for another hour, sweetie. Right? So get yourself something to eat. I'm gonna do this podcast, and I'll get you when it's time to go. I just got you up early. You're fine. This is the real fight, right? Because discovery is the phase of litigation that narratives are tested rather than asserted. It's where sworn testimony replaces talking points. It's where internal communications replace public summaries. It's where decisions defended abstractly become conduct examined concretely. And the filing on January 2nd makes clear that Lorain County is doing everything in its power to ensure that phase never gets reached. And, I've attached the filing itself and the story that I did, so you can go look at it yourself if you want, or you can listen to this and kind of get a Cliff Note version of it. One vote, no harm. The county's compressed story is sort of their whole defense rests on an extraordinary disciplined form of narrative compression. They reduce everything into a single act, right? There's just one vote. It's just one moment in time, right? According to this theory, the contract at issue lacked a fiscal certificate as required under Ohio law. The Board of Commissioners later voted to rescind it. That vote, the county argues, is the beginning and the end of the legal analysis, right? Under this framing, nothing else matters. No injury occurred, the county claims, because no valid contract ever existed in the first place. No retaliation occurred because the county is telling of the story. There was no adverse action beyond the legislative act itself. No constitutional rights were implicated because the legislative immunity insulates the vote and everything connected to it. The dispute stripped out of context, reduced to a technical defect, so to speak, and then sealed off from any further inquiry. And if that framing holds, nearly every claim in the case will collapse on cue. If the RICO claims fail because there's no proximate cause beyond a rescinded agreement, right? Then the due process claims fail because there's no protected property interest that could ever be vested. The First Amendment retaliation claims fail because under the county's theory, no adverse actions exist apart from the legislative vote, just that vote. Legislative immunity becomes the all-purpose shield for them, ending the case before depositions, document production, or even sworn testimony. And there's the picture. The entire case dies on paper. The January 2nd filing exists because that story only works if most of the record's ignored. CCI doesn't deny that a vote occurred, right? Nobody does. It does not attempt. I'm taking my allergy meds. Sorry. The rescission to pretend the rescission never happened, right? Instead, it argues that the county's fixation on that one vote is deliberate, and it's a deliberate misdirection. According to the opposition brief, harm occurred before the vote, alongside it, and after the lawsuit was filed. So at all three stages. The filing emphasizes that the federal law does not require all injury to flow from a single act, nor does it require a plaintiff to prove a valid contract to establish injury in to business or property. It's true. Federal law requires injury. Period. That distinction is critical because it determines the posture of this whole case. If the court accepts that the county's compressed narrative the dispute remains a legal abstraction resolved through doctrine alone. But if the court accepts CCI's framing, the case becomes a factual inquiry into conduct, motive, timing, and consequence. In other words, it becomes a case where we see that the facts actually do matter. That's precisely why that, January 2nd filing is designed to force the court to confront. It was pretty much a work of art. Legislative immunity, or how to turn one vote into a universal eraser, right? If Lorain County, had to summarize its legal strategy in one phase or phrase, I would say it would likely be this: legislative immunity fixes everything. And then the county's telling, once the Board of Commissioners voted, it's kind of a legal force field just descends over the entire timeline. Like what happened before the vote is even irrelevant in their mind because the vote happened. What happened after the vote is irrelevant because the vote happened. Anything that might otherwise raise uncomfortable questions is simply swept into the orbit that single legislative moment and declared untouchable because why? You guessed it, the vote happened. It's an elegant theory, and in the sense that it would be elegant if it had an ounce of truth to it. According to the county's filings, legislative immunity does not merely protect the act of voting, it protects the story that the county wishes the vote to tell. It protects the motives behind it. It protects the conduct that led up to it. And somehow it even protects the conduct that occurred after the lawsuit challenging the vote was already pending. Time under this theory becomes optional. Sequence becomes irrelevant. Cause and effect become inconvenient details that are easily ignored, right? In fact, best ignored. The January 2nd filing does not attack legislative immunity as doctrine either, folks. It attacks the way Lorain County is attempting to use it as a narrative eraser. And they really kind of are. Legislative immunity, as the courts have explained it repeatedly, to my understanding, and again, I'm not an attorney, nor do I profess to be one, but my understanding would be, as the courts have explained repeatedly, and you can read these in case briefs, protects legislative acts, right? It does not transform every action taken by a public official into lawmaking, though, either. It does not shield threats, retaliation, interference with third parties, or administrative conduct simply because a vote appears somewhere in the background, right? And it does not allow an official to retroactively launder non-legislative conduct through a later resolution and declare that the entire surrounding record is off limits. Put differently, legislative immunity is not a get out of discovery, free card. January 2nd filing is particularly pointed on that issue. It warns that accepting the county's framing would allow officials to collapse years of conduct into single legislative acts. And then they can claim immunity for everything that happened along the way, right? Under that logic, the more conduct surrounds a vote, the less reviewable it becomes. Accountability shrinks as activity expands. And the solution to any legal challenge is simple: schedule a meeting, take a vote, and declare the matter resolved. Done and done. Courts have not endorsed that approach, and they got a pretty good reason for not doing so. The filing emphasizes that the courts are required to look at the substance of the case, not at the labels, right? A vote that targets a single entity can be administrative in nature. A resolution can function as a retaliation rather than a policy making. And immunity does not attach simply because an action appears on an agenda somewhere. The presence of parliamentary procedure does not magically convert every surrounding act into somehow legislation. If it did, government accountability would depend entirely on formatting. What makes this section so quietly devastating is how little it needs to exaggerate. It simply just places the county's theory next to established law and lets the contrast speak for itself. Under Lorain County's approach, officials would engage in a course of conduct, face scrutiny, and then insulate that conduct retroactively by pointing to a vote and look, we voted, and declaring the entire matter legislative, right? But that's not how legislative immunity works. To my knowledge, at least, The fact that the county needs it to work that way tells you a great deal about how fragile its preferred story actually is, right? Because it's a convenient theory, and if facts were optional, it would be great. Before moving forward, it's worth pausing over what the county is actually asking the court to accept here. If Lorain County is right, then once officials vote, context just poof disappears. Sequence just dissolves. Conduct would just that would otherwise require some sort of an explanation becomes legally invisible, right? Accountability doesn't merely pause, it evaporates. In that world, the safest place for misconduct is near the agenda item, right? That's not cynicism. That's just logical endpoint of the county's argument. And if legislative immunity can be used to collapse years of conduct in a single vote, then the vote doesn't really legislate policy, it legislates reality. I want you to think about that. I mean, this is a crazy way of saying it, but imagine if you could just get off of anything that you did as long as you had a vote. So I could be like, listen, we really need to get this homeless problem taken under hand, right? Like, there's just too many homeless people. And they'd be like, all right, we're going to vote. I'd be like, all right, point of order before we vote. Bam! And then we vote. I mean, come on. I mean, I know that's ridiculous, right? But that's the thought process here, is like somehow this vote just magically did away with everything else that happened. It doesn't work that way. You know, it's the totality of circumstances, not one individual event or one vote. That's what makes the premise of this filing by CCI, and it puts it directly in front of the court. And that's why what happens in this timeline the next in this timeline matters so much, right? Because they're claiming that there was retaliation after the lawsuit, right? After they filed. When a timeline stops cooperating, Neath the county's immunity theory worked perfectly for everything that came before the lawsuit, right? Even if everything worked, the vote, everything, and was answered there, it still would not reach what happened after. Because that's what I see happening in a lot of other places too, like Lorain. It's not just about what you do before, it's how you handle it after. Are you still being a total jerk and doing the wrong thing? Are you still making fun of people on hot mics? Are you still being a-holes? Are you still withdrawing yourself and not giving people records? So even if their theory's right, it's not going to fix what they did after. Because according to CCI's opposition brief, again, I'm just reading the briefs. It's not my words. Not a lawyer. Lorain County officials apparently, according to them, engaged in additional adverse conduct only after CCI exercised its constitutional right to seek judicial relief. The filing alleges, and again, it's the filing, interference with tower access necessary to operate CCI's independent emergency communication systems. Not a proposed system, not a hypothetical expansion, an existing functioning system. This is the moment where county's compressed narrative stops cooperating, right? Post-filing conduct cannot ever be justified by alleged defects in pre-litigation contract. It cannot be folded into the legislative immunity and tied to an earlier vote. It cannot be dismissed as collateral when it affects the ongoing operations unrelated to the rescinded agreement. Because once a lawsuit is filed, the legal universe changes. Motive matters differently. Timing matters more. Retaliation becomes its own constitutional issue. The January 2nd filing makes this point with I hate saying the January 2nd because it makes me feel like I'm saying January 6th, which is that today? It is, right? Ooh. It alleges that these actions occurred, that the lawsuit was already pending, and that county officials themselves linked the interference to CCI's decision to sue. In other words, the filing doesn't ask the court to infer retaliation from coincidence. It alleges it directly. That matters because the courts have long recognized that government entities may not retaliate against contractors or citizens for petitioning the court. Maybe Lorain City should take that under account too. Because that protection doesn't just vanish when the party seeking relief once did business with the government, right? And it does not depend on whether the underlying dispute is ultimately successful. The right to seek judicial relief exists independently of the merits. Here, the county's strongest defenses depend entirely on right? Keeping the case frozen in time at a moment of the rescission vote, right? But retaliation that occurs after litigation begins refuses to stay frozen, folks. Hold on. It stands on its own. It requires explanation. And this is why the post-filing allegations are not really an add-on as much as they're a fracture point for this whole thing. They sever the county's attempt to use a single vote as a universal shield. They forced the court to acknowledge that the story did not end when the agenda items concluded. And they introduce a set of factual questions that cannot be answered through a briefing alone. At that point, discovery is no longer a burden. It's the new mechanism that the law provides for finding out what actually happened. And, I think, this is where their humor kind of turns dark, because if the county truly believes nothing improper occurred after the lawsuit was filed, then discovery is not a threat, right? It's actually an opportunity. Depositions would confirm that. Documents would corroborate that. The record would close the loop and answer the question. The only reason to fear discovery is if the timeline tells a different story than the one being repeated in the motions and out of your mouths. And that's exactly why Lorain County is trying so hard to make sure that timeline never reaches the witness stand or sees sunshine, because we all know people hate sunshine. I mean, that train wreck of CCI is just one of many problems that I've been talking about with these different stories, the governments, the local governments, that just blow my mind. Before I move to Act 2, I did want to point out with this whole CCI thing that, well, a lot of people don't really want to acknowledge the cost of this. At a city council meeting, I think, not this one that just happened, and not the one that happened previously. I think it was one before that. They voted $80,000 on the Harris radios or whatever it was, to have installed in 10 installed in retroactively in vehicles in Lorain. So we are still using two systems, and we are all still paying for it, and that's coming out of your tax dollars. I know. That's not okay. We need one system. If we were going to go with the one, we should have stuck with one, but the way they did it was just wrong. So that brings us to Act 2. We're going to do a little talking about Sheffield Lake and their soft landing problem, because if Lorain County is where these fights go hard in public, Sheffield Lake is where they go kind of quiet, or at least they used to. Not because nothing's happened there, right? Quite the opposite. Things happen in Sheffield Lake all the time. They just tend to resolve in a way that produces very little sound once the initial moment passes. Announcements are made, positions are staked, legal justifications are offered, and then slowly the volume drops. The case ends, the controversy fades, and then the public is left holding an outline instead of an explanation. And that's not coincidence, folks. It's method. Sheffield Lake matters in the story because it shows where the procedural containment looks like, what it looks like, and when it works perfectly. There's rarely a dramatic confrontation. There's rarely a final reckoning. Instead, there's process, meetings, counsel language, careful phrasing, outcomes that technically resolve the matter without ever answering the actual question that people were actually asking. That's what we call a soft landing. And in Sheffield Lake, controversies do not explode. They dissipate. And dissipation is powerful, folks, because when a case ends quietly, no one has to say who was right. No one has to say who was wrong. All they have to do, they don't even have to explain what evidence existed or what didn't exist or why the public should feel confident in the outcome. The institution survives the attack, the paperwork closes, and accountability becomes theoretical. This is where a CCI case starts to feel familiar, right? Even people who've never followed the emergency communications, contracts or federal litigation would see that the same instincts are at work here. Narrow the frame, control the narrative, end the matter before facts are tested in a way that produces permanent answers. In Sheffield Lake, this approach has appeared repeatedly in disputes involving government decisions, internal conflicts, legal interpretations that technically resolve issues without leaving substantive questions hanging in the air. The public's told that, oh, well, that's settled, but not what settled it, right? That it's over, but not what was learned. That the process worked, but without being shown how. And this is not corruption in a cinematic sense. There's no trench coats or briefcases. There's something more, I guess, durable than that. It's institutional muscle memory. Once an institution learns that it can survive, controversy without exposing itself, explanation becomes optional. Once it learns that silence carries fewer consequences than transparency, silence becomes policy. And once that pattern hardens, it begins to travel. That's why Sheffield Lake belongs in this story, because the CCI litigation is not just about whether Lorain County officials crossed legal lines. It's about whether they can avoid having to ever explain where those lines actually were. Sheffield Lake shows what happens when that avoidance becomes normalized. The ending arrives. The questions do not. And the audience, whether they realize it or not, is trained to just move the fuck on. Because that's where the humor starts to sneak back in, because it kind of has to, right? If you've ever watched a controversy conclude with a statement that says, essentially, after review, no further action is necessary, without telling you what was reviewed or why action was unnecessary, then you already understand the Sheffield Lake model, right? It's not about innocence or guilt. It's about relief. Relief that the thing is done. Relief that no one has to keep paying attention. It is government by sigh. And that's precisely why the county strategy in the CCI case feels so familiar to anyone who's watched these quieter endings accumulate across Northeast Ohio. Because what Lorain County is asking for is not exoneration. It's closure without clarity. It's the same move. It's just a higher altitude. In Sheffield Lake, the soft landing ends the story locally. In Lorain County, there's hope that legislative immunity ends it federally. In both cases, the goal is the same: reach an ending that resolves liability without resolving the truth. And once you see that, the transition to the state level becomes unavoidable, because it's not just Lorain County, right? Problem. It's not even just the Northeast Ohio problem. It's an American one. But that brings us to our third act here. Is like when the defense tries to disqualify the law. And that's kind of where we're at. Like, talk about the moment in this saga that should have been a procedural footnote, but instead it became a flashpoint. You published, I put out this piece, and it was the disqualification attempt that breaks the law, right? I was talking about the whole Aiden Fogel situation. And I know a lot of people wouldn't have thought that that'd be, but I'm about procedure. I'm about rules. I like the rules. They make me happy. And so, because that's exactly what it was an attempt to use a procedural quirk in the law as substantive roadblock, and in doing so to short circuit accountability rather than to advance it. And litigation motions to disqualify counsel are not really unheard of, but they're part of a playbook. When conflict is real, when ethics rules are implicated, a party can file a motion to disqualify opposing counsel. But here's where the line gets crossed. A disqualification attempt cannot be used against, as a sword to avoid facing the underlying facts, right? In the CCI case, that's exactly what happened. Instead of engaging with the substance of the allegations of reputational harm, interference with systems, retaliation that followed the filing of the lawsuit, county council filed a motion trying to disqualify opposing counsel, basically. Not because there was a genuine conflict that threatened the integrity of the process, not because there was an ethical line that was crossed. No, the attempt was tactical, a litigation lever pulled not to protect the client from impropriety, but to shift the battleground. It was, in essence, an attempt to avoid the fight by changing the fighters. And it should be a shock to no one that the motion was built on shaky legal grounds. My own story reported how the motion contravened, clear ethical and statutory standards. It tried to extend disqualification doctrine into areas where courts have repeatedly said it did not belong. It folded procedural absorption into the factual avoidance. And when you sit down and read the opinion attached to the motion, you could see what was going on. At least I could. Again, I'm not offering legal advice here. I'm not a lawyer. But in social work, we had to read a lot of books of law and social work and how they apply to these scenarios. And so at least I have the language down. And the language does not reflected genuine legal necessity. It reflected more of an appetite for distraction. And the flavor of strategy should be familiar by now, right? In Sheffield Lake, we just discussed questions don't get answered. They get folded into the process. Just fold it on in. And in the CCI case, when procedural defenses that would actually end the case before discovery began proved insufficient on their own, the next move was to try to disqualify opposing counsel, not because counsel had done anything wrong, but because the disqualification motion itself could push the case off its tracks. This playbook is as old as litigation itself. When you can't win on the merits, make the case about something else. And here's the thing that really matters is the courts don't allow procedural tools to be repurposed into substantive roadblocks. I should point that out to Miss Prue as well, because recently, she filed some stuff and she did it a week after I had filed something against her. And so she's utilizing the system as a weapon, and that's not what we're supposed to do. They don't permit a motion to disqualify counsel to become a substitute for factual development. They don't let legal theater stand in for litigation substance. And in this instance, the court rejected it, not because disqualification is never appropriate, but because in this context, the attempt to disqualify was untethered to any legitimate legal justification. It was a defensive play masquerading as ethics enforcement. What a moment like that illustrates is, and why it belongs here, is it's not just the county's defense team tied to a procedural gambit. It's the defense repeatedly attempts to use procedural packaging as a substitute for substantive engagement. At every turn, from one vote, no harm, to legislative immunity, to attempts to frame damages as non-existent, to motions trying to disqualify counsel, the patterns in the same, to avoid the underlying facts by reshaping the frame around them, right? That's the pattern we keep returning to as this episode unfolds, because it's not just one filing or one vote or one contract. It's about how power, when uncomfortable being watched and videoed, reaches for the legal perimeter instead of the factual center. And if you think that's a local phenomenon, just wait till we widen the aperture a little bit here in Act 4. And that's when this stops being about local and starts being to look familiar everywhere else at this point in the story, because some listeners are probably thinking, okay, this is Lorain County, small place, small politics, local personalities, local grudges. Surely this is just a homegrown mess, right? Well, that's comforting, I guess, if you think about it. It's also wrong. Because once you step back in the names and the filings and the docket numbers, what's happening here starts to look uncomfortably familiar to anybody who's watched corruption cases, accountability failures, or institutional meltdowns anywhere else in Ohio, or frankly, anywhere else in the country. Let's zoom out, right? The defining feature of the CCI litigation is not the contract. It's not even the technology. It's the method of defense. The county's not saying, here's what happened. Here's why it's justified. Here's the evidence. Let's put it all on the table. Instead, it's saying, you don't get to ask that or those questions at all. The move has a long pedigree. A lot of you guys saw it when you watched the news on the Householder scandal. You saw Larry Householder scandal. Long before the indictments ever dropped, early reporting was brushed off as speculation, right? Records were walled off behind nonprofits. Everything was lawful until suddenly it wasn't. The system didn't collapse because no one warned anybody. It collapsed because the warnings were procedurally ignored, just like now, until the facts could no longer be contained. You saw it in Norwalk with Ashley Ford, and which is important here precisely because it shows the other side of this coin. Ford apparently, they thought, crossed the line. Speech turned into threats in their mind, and the system responded. The case matters because it reminds us that accountability, can go both ways. But I feel like in this situation, she was a whistleblower. She was calling things out, and they used the system against her, to shut her up. I wouldn't be surprised if they start doing that to me. And when we start contrasting that with other areas, again, I'm not going to spend a whole lot of time talking about Ashley and Norwalk, but that's all. That's literally a whole nother 6 podcasts. But if you look no further than over there in Norwalk to see similarities in what's going on here, you can look in Ottawa County. You can go down and you look at these port of entries, and that's where your problems are coming in. And speaking of port entries, we talk about Vermilion and the surrounding jurisdictions. Their cases are being heard loudly and quietly. Charges get announced, investigations are hinted at, names circulate, reputations take hits. 10 months later, the case evaporates into a dismissal, a technicality, or a non-explanation. No findings, no narrative closure, just an ending. The pattern doesn't create accountability. It creates a fog. And that fog is useful for government because the outcomes are framed as procedural rather than factual. No one's fully cleared, and nobody is fully held accountable. Institutions survive the moment. The public is left with suspicion instead of understanding, and the same dynamic is at work here with the CCI case. The county's legal strategy does not seek a factual vindication. It seeks an ending, a clean procedural exit before discovery, before sworn testimony, before documents change hands, before anyone has to explain under oath why certain decisions were made when they were made. If successful, the result would not be exoneration. It would be another quiet ending, right? Quiet endings are the lifeblood of the institution and self-preservation, folks. Widen the lens again. Look at Cleveland. Look at the redevelopment projects that never quite deliver. Look at the financing structures that make sense only if no one asks too many questions. Look at Jobs Ohio, deliberately designed to operate in the shadows of public records law, justified in the name of efficiency, insulated in the name of growth. You can't request their records. You can request records to them, but not from them. Your logic is always going to end up being the same from them, right? Trust us. Details are complicated. Process is technical. You wouldn't understand. Oversight would just slow things down until it doesn't, until the bill comes due, until the mall deal collapses, or the Port Authority overextends, or the radio system fails, or they buy a freaking motel, no-tell, motel, or the public realizes what they've been told was, just a lease was actually the linchpin holding the entire structure together. And by the time that happens, the procedural defenses are already in place. Immunity's here, folks. Jurisdiction's there. Standing everywhere. The story's compressed. The context disappears. The accountability is framed as unreasonable. That's why the CCI filing matters again, beyond Lorain County. It's not just pushing back on the motion to dismiss. It's pushing back on a style of governance, a style of lawyering, a style of institutional survival that says the safest place for the truth is somewhere no one is legally allowed to look. And again, that's where the humor comes back in, because if you don't laugh at this point, you're going to lose your friggin' minds. We're asked to believe that entire systems can rise and fall, reputations can be destroyed, businesses can be sidelined, public money can be spent, and yet the only thing that legally matters is whether one piece of paper had the right stamp on it at the right moment. It's not law. That's performance art. That's the whole idea behind that contract refusal, is another right stamp or something. After the January 2nd filing is calling it what it is. Basically, it's saying politely but firmly, no. How about no? You don't get to turn years of conduct into a single vote. You don't get to use immunity like a get out of jail free card, and you don't get to demand public trust while refusing public scrutiny. There are commissioners. And that brings us to our final little turn in this story, because once you understand that pattern, the question stops being whether this case should go to discovery. The real question becomes, what does it mean if it doesn't? We look at Vermilion and their quiet endings problems. Vermilion matters not because it's the biggest city, the loudest controversy, or the most scandal-ridden jurisdiction in Lorain County. It matters because it looks calm, it looks functional, and yet When you examine what's happened there over the last several election cycles, the legal skirmishes, you begin to see the same structural behavior that appears in the larger and more chaotic disputes. In Vermilion, power does not usually clash in open combat. It dissolves, it deflects, it concludes without explanation. Start with something that should never be a footnote: a city council seat left open because no candidates were filed to run. Ward 1 was just simply vacant, right? They didn't have nobody. No scandal, no resignation, no recall, just nobody. On paper, it's legal. Practically, it's a warning sign. When nobody steps forward to represent an entire ward, the issue is not just political apathy, it's civic exhaustion. It suggests a system where participation no longer felt meaningful enough to justify any cost of engagement. I know that feeling. Now, layer that onto what happened next. Vermilion voters exercised one of the clearest forms of democracy authority available to them. All right, before we get into the charter movement, I do want to point out the whole idea behind that little story there with the Vermilion thing is that they only posted it in a small area, and now they're posting it in a bigger area, and that's being given out to everybody. The whole of the ward will be able to decide if they want to have people there, and I do believe that they're making a lot of great headway in Vermilion. I think it's a place to watch because I think they might be getting it right. But I also think that's a lot to do with the people that the citizens have elected to guide them, because they've been given the path by people who show them what these people have been doing. So when you look at the Vermilion voters, they approved a charter amendment requiring voter approval for certain, TIFs, tax increment financing arrangements, and that's about giving tax discounts to businesses that come in. This was not ambiguous outcome, right? It was not a razor thin margin. It was a direct expression of the public will on how economic development decisions should be made and who should have a say in them. And the response from the city leadership was not education, adoption, or acceptance. It was to litigate. The city moved to challenge the voter-approved charter amendment in court, arguing that the very mechanism that the voters used conflicted with the higher legal authority. In other words, the electorate followed the rules, won the vote, and then watched as the institution they governed turned to lawyers to undo the result. That's where Vermilion stops being about a local curiosity and starts being a case study, because what the public sees in those moments, like, this is not simply a legal disagreement. It's a pattern where outcomes are tolerated only when they align with institutional preferences. When they don't, the result is delay, challenge, and procedural reinterpretation. The message to voters is subtle but unmistakable. Participation is welcome so long as it produces the right answer. I mean, you have no further to look than the marijuana laws that they just changed here in Ohio and the hemp laws. The voters spoke. The government was like, F off. But that's the quiet ending problem, right? Cases begin loudy, elections are promoted, charter amendments are debated, public interest is engaged, and then when the outcome lands somewhere inconvenient, the resolution just happens quietly. A lawsuit here, a dismissal there, a ruling that turns on technical grounds rather than factual ones. The public's rarely told whether or not the underlying conditions or concerns were valid, exaggerated, unsupported, or simply ignored. The only certainty is that the issue is now over. Reputations remain bruised, trust erodes incrementally. Citizens who participated in good faith learn that winning a vote does not necessarily mean winning the argument. And institutions learn something else entirely. That controversy can be survived without explanation so long as the ending is procedural. That's not unique to Vermilion. It's simply clear there because the scale is smaller and the facts are easier to trace. When city council seats sit empty and the voters approve a change in the charter and the government responds by suing its own electorate, the thorough line becomes impossible to ignore. The system is still operating. The rules are still being followed, but the relationship between the public and the institution has shifted. Process becomes a buffer instead of a bridge, and that brings us right back to the CCI stuff. Lorain County's defense does not seek a factual resolution. It does not invite discovery. It proves that this conduct was justified. It doesn't invite discovery to prove that its conduct was justified. It actually seeks an ending, a procedural one that resolves exposure without resolving the truth, one that leaves the public knowing only that the case is closed, not whether the allegations were accurate or the conduct defensible. Same muscle memory there. This is at work in Vermilion. The ending is a lawsuit, a charter amendment. In other cases, it's a dismissal, a technical ruling. In other ones, it's a procedural bar. In the CCI case, it's a legislative immunity, one vote, no harm. Different tools, same objective. In Lorain, it's the gun lawsuit. It's one of many, 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 many other lawsuits in First Amendment and other areas that they have. Quiet endings protect institutions. They do not serve understanding. And once that approach becomes normalized, accountability becomes optional. Not because laws are broken, but because facts have never been tested, because the public is trained to accept the conclusions without explanations, outcomes without clarity. Vermilion matters because it shows us how easily that this becomes routine, how often a system can absorb public input without actually responding to it, how governments can, remain legally intact while becoming democratically hollow. When you see the pattern, you'll see it. And it's a small city like that. It's much clearer and easier to recognize. When it shows up at the county level, the regional level, or the state level, it gets a little harder. That recognition is where the real story continues. When you zoom out further, the pattern locks in it. At some point, with every long investigation, there's some individual facts that stop feeling isolated, and they start feeling, like they're snapping together like magnets. And that's because that's where we're at now. Because once you understand that what's happening in the CCI filing, you see that the quiet endings in Vermilion, once you recognize the procedural evasions in Sheffield Lake, you start to noticing the same defensive architecture everywhere. Everywhere else you look, different players, different facts, same moves, same tactics, same playbooks. And that's the part where people start to say, oh, you're connecting too many dots. Well, that's usually what gets said right before the dots connect themselves, folks. Let's fucking saying it. Like, let's talk about that damn mall. For years, Northeast Ohio has been promised a revitalization through redevelopment projects that look great in presentations and collapse under scrutiny. The Midway Mall saga is a perfect example. What the public was told was a simple deal, a lease, stepping stone towards renewal. Turned out to be the linchpin holding together a much larger structure of financial assumptions and political promises. And when that structure began to wobble, the response was not transparency, it was minimization, right? It was reframing. This is how it's being handled without ever explaining how or by whom. Sound familiar? New Russia Township, push towards village formation and mega site development. Again, the language is aspirational, jobs, growth, opportunity. But scratch the surface and the same questions appear. Who benefits? Who decides? What records are public? What agreements are binding? And in the grand scheme, what happens when residents ask too many questions that don't fit neatly in the development narrative? In those moments, the machinery activates, the records start to be hard to find, meetings become technical, jurisdictions become complicated, the public's told things are lawful, proprietary, or still under review. Details always come last. Later becomes rarely, and then and never. This is not accidental, it's institutional muscle memory. The thing that appears at the state level with Jobs Ohio, an entirely intentional design to sit outside the reach of the traditional public record laws, sold as efficiency, defended as necessity, operated in secrecy. The argument's always the same. Transparency would interfere with effectiveness. Oversight would slow progress. Trust us. And then when our deals go sideways or outcomes fail to materialize, there's no clear line of accountability because the system was never built to allow one. What ties all this together is the corruption in the cartoon villain sense, is that seeing something more banal and more dangerous. It's the normalization of government that prioritizes insulation over explanation, process over truth, endings over understanding. And that's why the CCI filing matters so much, because it threatens to interrupt that cycle. If discovery happens in that case, it's sworn testimony taken, documents are produced, the story can no longer be compressed into a single vote or a single technical argument, and it becomes messy, becomes human, factual. And that's exactly what the institutions are designed to prevent. And we get a little more humor here because without it, it all sounds unbearable. We're asked to believe that nothing meaningful ever happens until a lawyer says it does. That years of conduct can be erased with a well-timed emotion, and that the public confidence should survive on vibes and assurances. That accountability is something that we only do when it's convenient. That's not how trust works. Trust is built on when institutions explain themselves to us, even when they don't have to. Accountability exists when officials answer questions, even when they would rather not. And legitimacy survives when outcomes are defended on facts, not hidden in procedure. What we're seeing across Lorain County and across Northeast Ohio and across the state is a slow drift away from that model, not through scandal and explosions, but through quiet normalization. Another dismissal, another technical ruling, another lawsuit against voters, another case that ends without anyone ever explaining what actually happened. And the people feel it. That's why council seats go unfilled. That's why public meetings feel hollow. That's why residents stop showing up till something finally breaks. I mean, they don't even respond to my emails. They say message us, talk to us. Bullshit. Bullshit. That's all I know. And that's the problem, is that, we start looking at this through that lens, and that becomes my problem, is that it is.
Bullshit. 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 Bullshit.
It insists that public powers exercise that can't be examined, or it can be, I'm sorry, the CCI filing is allowed on purpose. It refuses to let the county end the story on its own terms. It insists that the public power can be examined. If harm is alleged, it can be tested. If defenses are raised, they can be challenged with facts. That insistence is not thorough line. Not just here, everywhere. Because whether you are talking about a radio system, whether you're talking about a redevelopment project, a charter amendment, a township mega site, the question is always the same. Do we get the truth, or do we get an ending? Lorain County is just betting on the ending. January 2nd filing is just betting on the truth. And that's what happens. Next will tell us a lot about, which bet wins. This is about, this is where the story pauses for now, not because it's over, but because the next chapter depends on what the count allows the facts to actually, the court actually allows the facts to be. That choice keeps reappearing. Every one of these stories eventually collapses into the same fork in the road. It doesn't matter whether we're settling in a county courthouse, a city council chamber, a township hall, or a federal docket. The choice is always the same. Do you resolve conflict by explaining what's happened and by ending the conversation, or by ending the conversation before the explanation is even required? That choice is what separates accountability from administration. Lorain County's response to the CCI case tells us exactly what side of the line the institution's chosen. Not once in 2 years has the county stepped forward and said in plain language, here's the full sequence of events. Here's who made what decisions and which. Here's why those decisions were justified, and here's why that documentation supports them. Instead, the county has offered a tightly scripted legal narrative designed to make those questions legally irrelevant. One vote, no harm, case closed. One vote, no harm, case closed. One vote, no harm, case closed. That's an argument about truth. It's an argument about jurisdiction, right? That's all it is. It's not an argument about truth. It's only about jurisdiction. It's about timing. It's an argument about immunity. It's an argument about whether the public ever gets to see what's behind the curtain at all. Pay no attention to the man behind the curtain. Once you recognize that, you start seeing the same choices play out everywhere. Sheffield Lake, unresolved questions do not get answered. They age out. They drift into procedural limbo. The public is told matters are under review, and then the review quietly ends without resolution. Just like those stupid Brit perk certificates that they didn't have to get until the very end of their term. But, what are you going to do to people that left? The system survives. The questions do not. And Vermilion voters don't even know exactly what they're told to, voters do exactly what they're told to do now. They participate. They pass a charter amendment. They insisted that the result becoming the starting point for a public conversation about governance. And it became the basis for a lawsuit designed to stop that conversation altogether. In Norwalk, the Ashley Ford case stands as a reminder that accountability can still exist when facts are tested, in some ways, but, they want to make her the bad guy. And she's been out there exposing things to people that really at this point shouldn't surprise any of you. And, maybe it's time we stop going after the people that are calling out the injustices and start going after the people that are committing them. But at the state level, Jobs Ohio operates on a theory that secrecy and efficiency is oversight and hindrance. Development is promised, results are delayed, records are shielded. When outcomes fall short and there's no clear line between decision and consequence because the systems were never designed to allow it. At the regional level, redevelopment projects like that mall are sold as inevitabilities until they fail, at which point they become technicalities. It's just a lease, just a misunderstanding, just a delay. just to vote. The public's never told how much was known when, or what was approved when, or who knew what when, based other than anything and assumptions. In New Russia, the residents were asked to trust the process again. Megasites, growth, opportunity, all framed in language that discourages questions by labeling them as obstructionist or premature. The same pattern repackaged. And here's the uncomfortable truth: none of it requires bad actors in the comic book sense. It only requires institutions that have learned they can survive without explaining themselves. They can outlast scrutiny by exhausting it. That quiet ending is safer than the honest answer. Kind of like when we tell a kid, just tell the truth. Honesty is the best policy. That's why the CCI filings matter so much, folks. It's not loud because it's dramatic. It's loud because it says, it refuses to end quietly. It refuses to accept a public dispute involving public power should be resolved with public understanding. It insists that if harm is alleged, it should be examined. If retaliation is claimed, it should be tested. If immunity is asserted, it should be applied narrowly, not as a blanket eraser. This is not about not liking CCI. This is about rooting for a vendor either. It's about whether the facts still matter more than the framing. Because once the courts start to normalize endings without inquiry, everything else follows. Participation declines, court seats go empty, voters disengage, trust erodes. Same institutions that complain about cynicism quietly benefit from it. Cynicism is predictable. Accountability is disruptive. And here's where this episode lands. The real issue is not whether Lorain County wins or loses the motion to dismiss. The real issue is whether the system still believes that discovery has value, whether sworn testimony still matters, whether public institutions are willing to actually let their actions be held and examined instead of merely defended. If the case proceeds, the story gets harder, messier, more uncomfortable, but also more honest. If it ends now, it'll end like so many others, quietly, procedurally, with a whimper in the night, with no one fully cleared and no one fully accountable. That's the choice that always keeps reappearing, right? Not in just this case, everywhere. For now on, the filings on the docket, the arguments are on the table. The silence from Lorain County tells you everything you need to know about the outcome they prefer. The question is whether the system will allow this or that. And that's where this chapter pauses, not because the story is finished, but because, this next move belongs to the court. And discovery will create a record that cannot be spun away. It does not rely on summaries, press statements, or selective timelines. It relies on sworn testimony, contemporaries, documents, internal communications, decisions placed back into the sequence in which actually occurred. Discovery is where intent stops being inferred and starts being examined. That's why so many of the defenses you've heard throughout this episode are designed to prevent it. Legislative immunity is not inherently corrupt. Judicial defenses are not inherently improper. Motions to dismiss are not inherently bad faith. But when every road leads to the same destination, no discovery, no testimony, no document, no explanations, the pattern stops being coincidental. How about no emails, Pat Riley? How about no emails, Lorain Law Department? It becomes diagnostic. And in the CCI case, Lorain County is not asking the court to weigh compelling facts or competing facts. It's asking the court to declare the facts do not matter. That whatever happened before the vote, during the vote, and after the lawsuit should just never be examined because a single legislative act supposedly absorbed it all. And that's not how accountability works in a functioning system. Accountability doesn't mean everyone's guilty. It doesn't mean allegations are true. It doesn't mean the government loses. It means the process allows the truth to be told and tested. That's it. We know what accountability looks like. When it happens, because we've seen it. When they tried to go after people, and we've seen it when they haven't. Saw it with Householder. The facts were examined, the outcome were visible. People could agree or disagree with the result, but they couldn't claim the process was hidden. That's the difference. Quiet endings deny that clarity. Over time, that guessing hardens into distrust, and distrust hardens into disengagement. That's how council seats go unfilled. That's how voters stop believing charter amendments. And that's how public meetings become performance instead of participation. That's what's risk of facing Lorain County right now, folks. And if this case ends on a procedural grounds alone, without discovery, without testimony, without documents, the county may win an emotion, but it'll lose something else. It'll reinforce the belief that public power is exercised behind closed doors and defended in a way that the public is never meant to understand. And that belief does not stay confined to one case. It spreads. It spreads to redevelopment projects. It spreads to tax policy. It spreads to zoning decisions and mega site plans. It spreads to every movement and every moment where the public is asked to trust first and ask questions later. And eventually, later never comes. And we're not here predicting outcomes. We're about recognizing patterns. The pattern is not very subtle anymore. The power is question. The response is not explanation. It's insulation. It insists that if the harm is alleged, the system must be willing to look, right? It insists that immunity has limits. It has to insist that retaliation after a lawsuit cannot be waved away by some paperwork or a mystical vote that happened before it. Whether the court agrees will determine what happens next in this case, but regardless of the outcome, the filing has already done something important. It made the strategy visible. And once the people can see the strategy, they start to see it everywhere. That's how accountability starts, folks. Not with a verdict, not with a headline, but with a refusal to accept endings that explain nothing. For now, the record's open, the silence is loud. The question remains, and the same one that we've been asking all along is, do we get the truth or do we get another ending? And that's where we're going to leave it, folks. But, if you take nothing else from this episode, take this. What's happened in Lorain County is not unique. It's simply visible. The Cleveland communication filing matters not because it guarantees a particular outcome, but because it forces a choice that institutions have been avoiding for years. Either we examine what happened or we accept findings or we accept endings that explain nothing. Either facts matter or procedures become substitute for the truth. For too long, the second option has been treated as normal. We've watched cases begin loudly and end quietly, right? And in the grand scheme of things, we've watched these public disputes dissolve into technical rulings. We've watched voters win elections and then lose the meaning of their votes. Over in Sheffield Lake is prime example. We have watched council seats sit empty while litigation flourishes. We've watched redevelopment promises collapse into footnotes. We've watched public power retreat behind legal doctrine and law departments instead of standing behind the explanation. And every time that happens, the public is told the same thing. This is lawful. This is routine. This is how it works. Shut the fuck up. Right? Lawful doesn't mean legitimate. Routine doesn't mean healthy. And how it works is not the same as how it should work. Accountability is not punishment. Accountability is not chaos. Accountability is the simple act of letting facts be tested in daylight and sunshine. It's letting sworn testimony exist. It's letting documents speak. It's allowing questions to be asked and answered instead of buried. That's what discovery does. And that is why it's resisted. If this case proceeds, we will learn some things. We definitely will. Some of them may be uncomfortable for some people. Some of them may be exculpatory. Some of them may complicate the narrative. But this is how the truth works. And if it ends now, we will learn nothing except that the system prefers silence to scrutiny. This episode hasn't been about rooting for a party. It hasn't been about liking a company or disliking it, commission or commissioners. It's about whether public institutions still believe they owe the public an explanation when their actions are challenged. Because once the obligation disappears, everything else follows. Participation declines, trust erodes, cynicism hardens, and the governance becomes something done to people instead of with the people. That January 2nd filing it just is not accepting that trajectory. It refuses to end quietly, and whether the court allows it to proceed or not, the refusal matters. And that's why this platform exists, not to chase outrage, not to manufacture scandal, but to read what others do not want to read, to follow stories past their convenient stopping points, to document patterns that only become visible after you refuse to let them fade. The story's not over, neither is the work. If you care about how power operates and no one's watching, stay with us. If you care about public records, court filings, and the space where law and accountability actually collide, this is where we keep showing up. Because the only way these stories ever truly end is when no one's paying attention. And we're not going anywhere, folks. I want to thank you guys for tuning in this morning. I'm going to get my kiddo to school here in a few. But you guys make it a wonderful day and a great start to this new year. And thanks for tuning in. And we'll see you guys in the next podcast. In the meantime, if you want to know more about this, go over to www.Aaron Knapp Unplugged. Or is it Unplugged with Aaron Knapp? I don't know. Anyway, go over to my website, check out the story. I posted this story on the Substack, on the regular site, put it out on the Facebook page. You can read the full story. You can see the full filings there. And when I get some more information and check Pacer again, I'll let you know. In the meantime, law enforcement, be lawful, not awful. Lorain City, give me my records. The rest of you guys, be safe and dry out there this morning. Try to stay warm.